All right, here we go. So we've got, what, 1, 2, 3, 4, 5, 6, 7, 8, 9 bills to get through today. We're going to start off with Heather with Senate Bill 649.
Thank you. This bill requires the clerk of the circuit court to pay $15 of the fee for performing a marriage ceremony in Frederick County to Heritage Frederick. Heritage Frederick must report annually to the Frederick County Executive and the Maryland Historical Trust on the use of all funds received under the bill. The Frederick County Executive, or MHT, may request an audit of the financial records of Heritage Frederick at any time.
There's been a motion for I'm kidding. All right, motion favorable. It's been seconded. Is everyone okay? All right, great. All right, now we'll go to Senate Bill 703. Josh.
Senate Bill 703 authorizes a person to operate a golf cart on a county road in Frederick County, subject to certain limitations and requirements. The county may, by local law, designate the county roads on which the authorization applies and establish further safety requirements.
It's been a motion.
Does it got the amendment to be Frederick County Senators? Oh, I'm sorry, I'm looking at the wrong person.
Yeah, we can do that.
Yeah, I just want to make the Frederick County Senators. That's
All right, this is amendment to add both Frederick County
We're
Senators.
both on there. I want to entitle it Frederick County
Got it.
Senators.
To change the title to Frederick County Senators, is everyone okay adopting that amendment? Senator Sidnor, sir.
Is this a statewide issue? I mean, that's what I wondered, but I digress.
Lake Linganore is self-contained.
All right, so the motion is for favorable with amendment. It's been seconded. Is everyone okay? Okay, great. Now we'll move on to Senate Bill 731. Josh.
Senate Bill 731 requires a person who tows a vehicle to notify any secured party electronically if that form of notice is agreed to by the tower and the secured party.
There's been a motion for favorable. It's been seconded. Is everyone okay? All right, great. Bill passes unanimously. We'll now move on to Senate Bill 746.
So this bill, there is an amendment in your packet. So this bill alters the annual salary of the sheriff of Frederick County. So the amendment in your packet, it alters the sponsors to be the Frederick County Senators. And then also it specifies that the salary as amended, it will be $140,000 in 2023 and 2024, and $150,000 in 2025 and each year thereafter.
It's 125 now.
Correct.
But just so we know, his county pays for it. It's not a state paid position, right? So it's not our money.
The bill's been moved and seconded. Everyone okay with this? All right.
Well, that's on the amendment.
Okay.
In 2026 as well, right?
Yep.
Okay.
Okay. Everyone okay with the amendment? Did we adopt the amendment? Okay, the amendment's been adopted. Everyone okay with the bill? All right. That's 746. Heather, do you have any other bills?
Senator Smith's bill is going to be held.
Okay. So we're holding,
The next one is,
You said we can go to 819.
oh, yeah, let's do that. Senate Bill 819. Oh, that's right. All right, let's just take
That's Jamie as well.
That's Josh.
Is that Josh? Okay,
with everything, the package.
got it. Okay.
Senate Bill 763 requires the Administrative Office of the Courts, with the cooperation of each state's attorney, to collect and disclose to the Sentencing Commission specified information related to each prosecuted case. The commission would publish the data online by May 1, 2024. There is an amendment in your packet that is number 733620/1. The amendment does a number of things. First of all, it adds, beginning at the bottom of the first page of the amendment and carrying over into the second page, or rather the bottom of the reprint, it adds a provision in the Correctional Services article which requires the Division of Parole and Probation to report annually to this committee and the House Judiciary Committee on certain things. So there does need to be an additional amendment to that piece of the reprint, which is that at the top of the second page of the reprint, item 1 there should be struck from the bill entirely. And in the new item 2, which lists the specific crimes that would be included in the report, the crime of robbery should also be struck. Moving on through the reprint. Sorry, this is, so the second page, which is unnumbered. So there's a new item 1 there, which is part of what the division would have to report to the General Assembly. That item should be struck in its entirety. And in item 2, the word robbery should be struck from there. Moving on through the reprint, after that provision in the criminal procedure article, this is where the data reporting from the state's attorneys is. So there's on top of page 2 of 12 in the new subsection C, there's a definitional change to the word charge, which has the effect of limiting the data collection to cases which result in a conviction in the circuit court. Moving through, some of the definitional language is struck to reflect changes that were made later in the bill. Beginning on the bottom of page 3 of 12 of the reprint is the data collection provision. So the first thing that you'll notice at the bottom of that page, the Administrative Office of the Courts is struck from that provision. They are struck from the entire bill, so their role no longer exists. The data would be reported straight from the state's attorneys to the Sentencing Commission. Moving on, a number of the more specific pieces of data which the bill originally required to be reported have been struck out from the bill. On page 4 of 12, one thing I would note, there does need to be an additional change on line 13. It currently reads the arrest date. It should read the date of the offense. That would bring that piece in line with the data that is currently recorded and collected. Moving on, there's a change to on line 23 of page 4, which just changes the way that piece of information is reported. Rather than reporting whether the person was eligible for court-appointed counsel, it would be reported whether they were represented by private counsel, a public defender, or a court-appointed counsel, or proceeded pro se. Again, that is to reflect data which is already collected. Moving through, there's a change on page 5 of 12 to the provision which requires reporting on whether diversion was offered. Instead of reporting whether diversion was offered, it would be whether diversion, problem-solving court, or an alternative sentencing procedure was offered. And the more specific information about the offer of diversion is struck from the bill. Moving on, the rest of that page is more items that are struck. Page 6 of 12, again, most of those items are being struck from the bill. Again, page 7, again, includes a lot of more specific information being struck from the bill. And then again, there are more provisions which reference the Administrative Office of the Courts, which are being modified to specify that the data goes directly to the Sentencing Commission. A number of provisions are struck from the bill, again, on certain data that the state's attorneys would be required to provide about their own internal policies. And that is for the next several pages, going all the way down to page 11 of 12 of the reprint. On line 14 of that page, the deadline by which the commission would have to report the data publicly is moved back from 2024 to 2025. And then on page 12 of the reprint, there are provisions being added from the education article. And these provisions make a change to the definition of student data as it relates to the Maryland Longitudinal Data System Center. The purpose of this change is to allow the Department of Public Safety and Correctional Services to enter into a memorandum of understanding with the center to share certain criminal justice-related information. And then finally, on the unnumbered page after page 12 of 12, in the new section 2, the bill would establish a task force to study criminal justice data transparency. And the purpose of the task force would be to study the possibility of expanding the data collection and disclosure requirements in the bill to include district court cases and to make recommendations on potential statutory changes to expand the reporting. And the task force will be required by December 31st, 2023 to report any findings and recommendations to this committee and the House Judiciary Committee.
All right, I know Vice Chair Walser has a quick question, and then I want to kick it over to Senator Sidnor and would invite Senator Huff and Senator Carter to chime in, because I know you sat in on the work group.
Thank you, Mr. Chairman. Josh, I'm a little confused by the definition of charge on page 2 of 12, where a charge is being defined as a conviction.
Yeah, so that was part of narrowing the scope of the data. It's a little bit unusual to do that, but it just has the effect of then, in the rest of the bill, when it says charges have to be reported, that means that those are only the charges which resulted in a conviction. It's kind of an unusual definitional way of doing it, I admit, but that's the effect of that definition.
So on page 4 of 12, where it's asking for the charges brought by the state's attorney, that means the charges that resulted in convictions.
Correct.
And then on page 5 of 12, it says whether the charge carries a mandatory minimum. That means whether the conviction carries a
Correct.
minimum. Do we just want to say it?
Do we just want to say charge means
Conviction.
charges that result in conviction?
Yeah.
Or just say it each time, a charge that has resulted in a conviction, whether the charge that results in conviction carries a mandatory minimum. I get what you're doing, that it cross-references, but it's using charge in a way that I think is not definitionally traditional.
That change could be made, yeah.
I think that's a good point. Can I elaborate on that for a second? So, on page 4 of 12, still talking about those same charges brought by the state's attorney. If we're talking about charges that result in conviction, that means we are not requesting a report of all of the charges. And I ask the question because typically state's attorneys charge everything except for the kitchen sink. And then it's whittled down to the minuscule charge that usually results in a conviction. And I would think that we would actually want to know what the 10 charges were and then the one that resulted in a conviction, if it's possible.
So-
Or is that your intent, or what is your intent?
This was a compromise bill, and simply just a way to put in a foundation so that these things may be expanded in the future. So this was things that the Maryland States Attorneys Association were agreeable to, just as like I said, as a foundation, and hopefully some of those things can be expanded into the future.
Okay, just objective, so we don't want to know the full gamut of charges brought. We only want to know.
Honestly, I want to know more, a whole lot, but,
And I think one potential problem,
that's the deal.
one potential problem with that is charges that are dismissed would then be expungible, and the bill requires the commission to maintain the records for 10 years. So that creates a potential issue because expungement would generally require any state agency to delete the data.
We already talked about that universal stuff. Yeah, I'll just pine in. I know they struck a lot from the bill, but quite frankly, kudos to you and my state's attorney just contacted me there in favor. they were so adamantly opposed, and I wouldn't say, we basically were yelled at, or at least Charles was yelled at for an hour. So kudos for you for working out something with him.
It's one meeting I was glad that I didn't attend. No, kidding. Okay, so can I make this, I'm gonna make a motion to adopt the amendment, and then I know there's another forthcoming amendment, but can we just adopt this real quick so we can work off of this? So the motion is to adopt this amendment, everyone's okay? All right, excellent. Can we adopt Senator Wall Striker's amendment as well on top of this? Amendment number 2? You're okay doing that in line? Okay.
I just, in looking at this further to what we were discussing today in another bill hearing, and on page 4, we asked for the defendant's race and gender. And I think it's important that we start asking for victim information, not just the defendant, but the victim's race and gender. Just bring the victims more into all of this data collection. If we just keep collecting on the defendants, it just seems so one-sided.
Again, if that's the will of the committee, I have no problem with that. This is just the deal that the compromise that I struck.
My concern, I don't want to screw up your bill, and I don't want to push something in here that's gonna, then they'll come back and say, well, we don't have the fields for that, and then, because as I understand what you've done here is,
Right.
they've said, here's our fields, here's what we can collect.
Right.
And you approved it all by then.
Right. So I think with this bill, there's actually maybe just 2 additional fields that are created so yeah, that's exactly what happened. So
Well, I'm not
creating additional fields, I don't know if that would then cause additional expense and the like.
Okay, so I don't want to screw up your bill, because I appreciate what you're trying to do here on the data collection, but, so I defer to you, Charles, but it's just an issue that I think we got to start bringing this stuff out.
I don't disagree.
Well, I'll tell you, I mean, look, maybe we can ask them, if it's a floor, it could be a floor amendment, let's pass it the way it is, and then I'll check with them. If it's something that's, I'll ask for a floor amendment, okay? Okay, all right, thanks.
All right, is this motion for a favorable with amendments?
You're gonna do that on the floor.
Huh?
You're gonna do the cast these on the floor.
Yes, yeah. Okay, everyone's okay? Everyone's good? That was good stuff, man. That was good stuff. It's really good.
Way to revive a bill.
All right, we're gonna, Senate Bill, all right, so we're gonna go with Senator Heddleman with Senate Bill 819.
So,
There we go. We didn't even know what's before us there.
So this bill is pretty straightforward. It requires the governor to appoint the executive director of the Governor's Office of Crime Prevention, Youth, and Victim Services, formerly known as GOCAP, with the advice and consent of the Senate. The executive director of the office must serve at the pleasure of the governor, and the executive director who is serving on the bill's effective date, which is October 1st, 2022, may continue to serve until 2 years after the bill's effective date and may be reappointed only after the expiration of that term.
So, Senator Heddleman, you want anything to say, or? Don't. All right.
Very favorable, unless other people have discussion.
is there any opposition to this one? I don't remember.
I didn't see any. Let me double check.
Okay, all right. I'm fine with it, I don't know.
All right, so there's a motion for favorable. It's been seconded. Everyone seems to have comfort. Look to answer your question. Is 819? Oh, okay. Should I say that out loud? There was one frequent flyer that was, yeah, the usual person. Okay, got it. All right. Motions for favorable and seconded. Is everyone okay? All right, passes unanimously. All right, so we'll go ahead, we're gonna move on to Senate Bill 861.
So Senate Bill 861 establishes the Maryland State Police Gun Center within the Department of State Police as a statewide firearms enforcement center for tracking, screening, and vetting all firearm crimes committed in the state. As stated in the bill, the center must create and maintain a statewide database to track information on crimes committed with crime firearms. Also, they need to coordinate with the Department of State Police and law enforcement agencies to screen and vet all firearm crimes committed in the state, and assist the Department of State Police and law enforcement agencies with firearm enforcement and firearm violation reduction efforts. Each law enforcement agency is required to report to the center information regarding crimes committed with crime firearms within the law enforcement agency's jurisdiction. The center must designate how often law enforcement agencies must report the information required and may require a law enforcement agency to report other information relating to firearm crimes committed in that agency's jurisdiction. There is an amendment in your voting packet. This is Amendment 223-022/1. The amendment, first and foremost, adds language that states that beginning in 2023 and each year thereafter, the governor shall include in the annual state budget an appropriation sufficient to fund the operations of the center. The fiscal note had indicated that between 2023 and 2027, the expenditures would fluctuate between approximately $2 million in later years and upfront, some years closer to $4 million. The committee could add specific language or go general. The general is more non-binding, but if the committee wanted, you could make it specific to each year. But that is just the first part of the amendment. The rest of the amendment adds provisions that the committee has actually discussed in previous sessions related to theft of a firearm. Provisions providing that certain parts of the law governing the use of firearms in felonies or crimes of violence, or stating or clarifying that possession is not use. It includes provisions providing for interlocutory appeals in firearm crimes, and affects the 14101 definition of a crime of violence as it pertains to use of a firearm in a felony or crime of violence, to remove a provision in 14101 that exempts possession with intent to distribute from the use of a firearm inclusion in a crime of violence. That was a mouthful. So would you like me to walk through, or?
Sure, just, I'll open it up for discussion. I'd like to, can we adopt the amendment to work off of the amendment to discuss, so we're all singing from the same sheet of music?
Gone over so far, but if
Sure.
you want to do those now, or wait till you adopt the amendment?
Can we just adopt the amendment and then, okay, is everyone okay adopting the amendment? Okay, great, sure, go ahead, Senator Cassidy.
On the bottom of page, let's unnumber, the first unnumbered page, says in this section, use does not include mere possession. Is that? That's what I thought. It does, right? That's case law. It's not really a new change in the law. It's really just a case law. Okay. Right. Okay. We normally strike the preambles. Are we leave those preambles on the final bill, or what? Do we want to include those?
I was actually just.
Just uncodify.
Take it
We
off.
normally in this committee, we've always taken off preambles.
Yeah,
Argument over it, and it's like, why?
I think it's good to take it off.
Okay, that's all my questions so far. Go ahead, Jamie.
Motions to remove the preamble. It's been seconded and everyone's okay with that? Okay. Further discussion? All right, so the motion that is for a favorable with amendments. Is everyone okay? Yes. Senator Sinner has a question.
Actually, I'd like to make an amendment and put my name on the bill. So,
I'd like to get on the bill as well. Senator Sidnor, I'd like to get on Huff. Senator Carter,
Does anyone
Senator
not
Watson.
wanna be on?
Everyone wants to be on it. Okay. All right, the whole committee. Jack wants to be on or no? Okay. So we adopted that amendment with everyone, and the motion's been for favorable with amendments. It's been seconded. Everyone's okay. Got it. We have one more bill left. And we have one more element to figure out. It's happening right now, so just, can we take a 2-minute break? We're almost done.
Can you do it 2 or you need 5?
5.
It's
All right.
not me.
It's not Jamie for one time. All right, 5 minutes. 5-minute recess, and we'll come right back.
on camera.
We are done with the entire list. So Senate Bill 452 I held to continue working on. And we, yes, we did. That was it. So now we are on Senate Bill 387.
So, as introduced, Senate Bill 387, with specified exceptions, prohibits a person from purchasing, receiving, selling, offering to sell, or transferring an unfinished frame or receiver as defined under the bill, unless it is required by federal law to be and has been imprinted with a serial number that's specified in the bill. Beginning on January 1st, 2023, the bill prohibits a person from possessing a firearm unless the firearm has been imprinted with specified information, a serial number. The bill also requires the Secretary of State Police to suspend or revoke a dealer's license under certain conditions relating to untraceable firearms. It establishes penalties for violations of the bill's provisions, specifically a 3-year misdemeanor, and expands the definition of a firearm to include an unfinished frame or receiver. The bill takes effect June 1st, 2022.
And you want to go over the amendments just piece by piece? How do you want to do it? You're on.
Yeah, sure. So there is an amendment in your voting packet, and let me just pull this up. Make sure I've got the right one. The amendment is 393025. And going off of the reprint, the amendment language starts on page 4. Specifically, this is beginning at line 19. This covers the conduct not covered by the bill. So this subtitle does not apply to a firearm that was manufactured before 1968. The new language would specify that it does not apply to a firearm manufactured before October 22nd, 1968. The reason for that is that the Gun Control Act did not actually require serial numbers on firearms until October 22nd, 1968. That was the effective date of that statute. Moving on to page 5, there is a mens rea requirement being added to the prohibition on possessing an unserialized firearm. That starts at line 11. So subsection B covers that possessory aspect, and it provides that this subsection does not apply to possession of a firearm unless a person knew or reasonably should have known that the firearm was not imprinted with the serial number described under this subsection. Following that, the prohibition on possession is kicked out from how it's drafted currently in January into March.
Can we just, real quick, for the mens rea, just talk about how
Sure.
the courts have kind of construed that anyway, since there's been a.
Right, so not all statutes, and just the chairman had just asked if I could explain sort of the mens rea aspect here. So not all statutes in Maryland contain an express mens rea. But there are statutes where courts have read in a mens rea. Usually that is a knowing mens rea. Courts use a factor-based test to look at whether or not the General Assembly intended for a crime to be a strict liability offense or intended for there to be a mens rea. There was a case, and the name is in my notes, but a recent case that dealt with unlawful or illegally transporting a firearm where there was a firearm offense that the Court of Appeals looked at the statutory history of a person who illegally transports or has about the person a firearm or a regulated firearm, and determined that strict liability applied based on the legislative history of that particular statute. So what this does is it clarifies, it puts it up front that there is a knowing requirement for a violation, and that requirement would be that the person knew or reasonably should have known that the firearm that they had wasn't serialized in accordance with what's laid out here in subsection B. So that's
Good, perfect.
cool. So moving on to line 26, there's an addition of a requirement, subsection C, which starts at line 23 on. Oh, I'm sorry, Senator?
Why did we push the date back?
Sure, they pushed the date back from January 1st, 2023 to March 1st, 2023. That's at line 12. This relates to the possession. So I guess there was some concern about, people having enough time to come into compliance and, find out about the new requirement. So that was pushed out by 2 months. So moving down to line 26, subsection C here on page 5 covers how the dealer needs to conduct the marking. So already in the bill, they're required to do it in compliance with all federal laws and regulations related to affixing serial numbers to firearms. But this specifies that the imprinting of the firearm with the serial number needs to be done with a serial number that is not duplicative of any other serial number imprinted by the dealer or licensee onto another firearm under this section. So they can't do the same one twice.
Otherwise
Moving,
compliant with federal regs.
and it still needs to be compliant with federal regulations. So that's left unchanged. And then moving on to page 6 of the bill, there was concern expressed, particularly about how the bill would be interpreted with respect to what readily completed means insofar as the framer receiver definition. So you may recall that earlier on in the bill, a framer receiver or the unfinished framer receiver has the meaning that it's a forged, cast, printed, extruded, or machine body or similar article that has reached a stage of manufacture where it may readily be completed, assembled, or converted to be used as a frame or receiver of a functional firearm. There was concern that the bill's silence on this would lead to some inconsistent interpretation with federal regulations, which the proposed federal regulation on the privately made firearms does provide some guidance on what readily completed means. So this would say at the end on bill page 6, and this was based on language that was suggested through the AG's office, that this act shall be construed in a manner that is consistent with proposed Federal Rule 2021R05 updating parts, and they're laid out there, published in the Federal Register. If the proposed federal rule is modified at the time of adoption, this act shall be construed in a manner that is consistent with those modifications. So the act, the construction of the act is meant to track with the federal regulation, regardless of what happens to it, up to the time of adoption. And that's the amendment.
So, there's another forthcoming amendment. Can we adopt this amendment and then build off there? It says, motion to adopt the amendment, everyone's good? Okay, great.
So there was some discussion about whether and this included the bill hearing about whether Maryland State Police should be tasked with having a registry of the ghost guns or privately made firearms. It was actually suggested during the bill hearing by a couple of folks that Maryland mirror in some way what DC had done. Now, the information we received was that DC allows people to come up with their own serial numbers and then provide those to the Metropolitan Police Department in DC, and in doing so, register their privately made firearms. So
we don't do that.
we don't do that in this bill. The way that this bill works is that you would take your firearm to, your unserialized firearm to an FFL. The FFL would imprint it with numbers from their FFL number, their license number, followed by with the amendment, a unique other number that they come up with. And then presumably they would enter that into their acquisitions and dispositions book. And if the firearm were recovered at the scene of a crime, law enforcement would be able to look at the FFL number, go back to the FFL, and ask to look at their A&D book, and find out the information of the person who had that firearm registered. So there's been I guess a couple of disagreements about whether the FFLs could do that or would do that. Some of the information received from FFLs, and this hasn't been verified, but some of the FFLs suggested that they believed that if they placed their number on a firearm, that somehow under federal law, they would become, for products liabilities purposes, the manufacturer of the firearm, even though they had never actually worked on the firearm apart from putting a serial number on it. So it was their belief that they would somehow become liable. And again, this, I haven't seen a regulation that said that, but that was their belief.
Well, that is, so I don't believe that either. I mean, I don't know. I can't verify one way or another, but it seems a little different. But the underlying point is that the folks that we've talked to have said that they would not the bill does not require them to participate in this, but they said that they will not do it for a multitude of purposes, and that's what the testimony has been. I don't believe that one reason necessarily, but I can't verify that one way or another, but that seems different to me. But the point is, they say they won't participate in this process. Here we go. We're about to tell you. Very good question.
So the proposal that I guess has been circulating is that MSP would receive the serial number information, and basically they would do registration in a manner that they prescribe through regulation, and be required to come up with regulations. And there's a process that, I guess.
Yep, do you want to say?
Yeah.
So you would go to a gunsmith or an FFL, get your serialized number, and then you would go and you'd submit your 77R form to MSP. They then have that information in a database, and they have in a centralized location. It's easily accessible to state law enforcement. Oh, and by the way, that triggers a background check. And so that you've got a two-step process there that, we think works.
State Police to set this program?
So it's not even setting, so they'll have to make some minor adjustments into their programming to be able to receive this new form when you're submitting your 77R, they have to make some field changes. But essentially, they do this already with voluntary registration.
They chisel the number into the.
No. So they're not responsible for that.
Who's
It
gonna
would
do
still
that?
be an FFL.
You still
but-
have to go out and get it, but it has to be compliant with federal regs.
But
That
it
num-
wouldn't be the FFL's.
Number.
License number that goes on to it.
But the FFL will do that. They can get that done at the.
The go- yes.
Gunsmiths, right.
Yeah, because they're not, it's not their FFL number, they don't have to put it in their A and D book.
So, okay, I see.
Or the gunsmith to put that serial number on.
Correct.
And to be clear, I think when the word gunsmith is being used, it's referring to a type 1 FFL,
Not
so
a type
the dealers.
7.
Right, the type 7s are the manufacturers.
Okay, so they would usually go to a type 1.
The-
Gunsmith, get the
Right.
number on the receiver, and then the next process would be to
Register with state police,
register with the Maryland State Police, right?
Correct.
which triggers an automatic background check.
And that's,
Okay.
that's something that the current bill
Does not have.
didn't require was an actual background check being recovered, or conducted.
So is everyone okay with that's the amendment, is everyone okay adopting that?
Yes.
Okay, so it's been adopted. Further discussion? On the bill and, yeah, sure, go ahead, Senator Huff.
The only other thing I have left is the penalty provision. I don't know if we're going to address that or not, but I think that was the only other opposition that came in, and I think that was reasonable, that if somebody has one of these guns sitting around from 1969 and they don't know about the law or didn't follow it, their request was that 3 years makes it, that they become a prohibited person. So if you drop that, I think it goes to what, 2 years? They're not, because 2 years in a day makes you prohibited, correct?
Correct, so for a felony is anything over 1 year, for a misdemeanor, anything over 2 years.
So, I mean, the only amendment that I can think of left is, and I think that's a fair request, is to put it at 2 years. Quite frankly, we don't use 3 years that often anyways.
Well, it's illegal possession of a handgun is 3 years.
Good.
Illegal possession of, I believe illegal possession of a handgun is up to 3 years, but it's a misdemeanor. But at any rate, I've said multiple times that I don't think that the seller that's doing this for profit with the intent to possibly even be a mass volume seller is the same as this person that Huff just described, that's in possession of an unregistered gun or an unserial gun, or even a purchaser. And so I've repeatedly said that I think that we need to entertain having different penalties for one versus the other. And so I see that's not here, so if,
Correct, so keep the 5
I definitely agree that the possessor should be a misdemeanor, and it should be under 2 years if 2 years is the bar. I don't want the possessor to be a forever prohibited person.
No, I'm fine with that. If we want to do a different, for the seller, make one penalty that's above the 2, and then, but for the person in possession, I'd ask we do it as a 2. I heard 5 years floated around, but, I mean, I would still suggest we make it a misdemeanor, though. I don't know that you want to make that a felony unless you have unless you have a good reason for that.
I don't suggest a felony, I just think the most important thing is that the possessor is not a prohibited person forever, which means whatever the sentence has to be, if it's, I'd even say 18 months, because I'm uncomfortable with the 2 years, it could be mistaken.
Gun registered to spend.
I
Correct.
mean, we can make it a year, really. 6
long time.
months.
I'm with you.
Okay.
It is definitely
I'll take 2
2
years.
years and more, it's not under 2 years, right?
It's exceeding 2 years.
So that's for the possessor. Well,
Under the amendment? Or, like?
I am not suggesting that both be,
No, I hear you. Let's see what you think about this.
Okay, so the language, I guess, would be, in order to comply with Apprendi, you basically need to distinguish the possessor from the person who sells one of these firearms. So you would need to create a new prohibition that provides that a person may not sell, is just the language is how it would read. A person may not sell, offer to sell, or transfer a firearm unless it is imprinted with a serial number described under subsection B of this section. So that's that serial number that's required by federal law or the serial number that's laid out in the statute. And then you would say that the person who, the person who brings in or sells or purchases or transfers those kits, essentially, that subsection A in page 5, that person is subject to the higher penalty that you guys are describing. So that, I don't know if it's a 3 years or 5 year felony.
5 years.
5 year felony.
Well, why do we want a felony versus a misdemeanor on that?
Yeah, I don't care if
It's
it's a
one-
felony.
you're still
I
prohibited
think so.
person
I think
either
it's
way.
important
You're
that
still
the
prohibited.
purchaser actually become a prohibited person, because then that hurts the bottom line, and then they can't continue to be in the business of selling. That's why I think that's important.
Yeah.
It doesn't have to be a felony.
I mean, do we match, I mean, does that match other things on a 5-year felony, though? I don't know.
Well, generally a violation of the
You're selling.
regulated firearms subtitle in public safety is like, it's just a general 5-year misdemeanor. So.
I'm just a little uncomfortable with a 5-year felony. 5 years I'm fine with a felony. I'll tell you why I'm not. Because I'm not an expert on this, but if I'm missing something and somebody sells a piece of this and, sells, does it have to be the whole kit? What if they just sell the receiver or something like that? Or, I mean,
So
a
what's-
felony's really harsh. I mean, you're talking the collateral consequences. It's not just guns. I mean, they're obviously going to be dispossessed of their guns after this, but a 5-year felony's got everything else. You're talking losing real estate licenses, all kinds of stuff.
I don't think it has to be a felony either. I think that it just has to be that they are prohibited and there's a stiffer penalty.
And we're going heavier than the bill. I mean, the bill that came in was 3. I mean, she puts it up to 5.
Yeah, we're also dropping the other.
What about for subsequent violations, maybe, to make it higher for subsequent violations?
I don't have a problem with a subsequent. I don't have any problem. Whatever you want to do
Well,
on
the first
that.
violation, can't they get a PBJ anyway? I guess, because it's not a conviction.
It happens all the time. I mean, not all the time, but it's negotiated, so you can have a PBJ, but then the state can still say, but I want this person to be treated as a,
Disqualified.
yeah.
Well, what did we do on a? Oh shoot, we didn't do the subsequent offender stuff in the this other bill. I suggest we leave it alone then.
I mean, while Jamie's looking for that, just to speak up for the harsher penalties for sellers, including making it a felony, I mean, the policy outcome that we're looking for is to shut down the market and to get these off the street. And the easier way to shut this down and to get these off the street, I think you're exactly right, both Senator Carter and Senator Huff and Senator Lee are saying this, dealing with the sellers is the better way to do this, even as we're dealing with both. And if you're going to do it, you have to be serious about it. You have to have consequences for it. And selling an illegal, unserialized weapon is a serious offense. And you have to know it's unserialized because we added the mens rea in the amendment that we just adopted. And so to me, a 3-year felony or 5-year felony is completely appropriate for knowingly selling an illegal firearm. And just to be clear, when you're selling an unserialized weapon, the buyer on the other end, you know something bad is going to happen. That's why that person wants that weapon. That's why they want it unserialized. And so if we're going to go down on mere possession because we don't want to get folks caught up, I think it's completely appropriate that we go up on sellers.
Just, you gave this nice handout of the regs and everything. We're talking about what makes this a firearm now under this particular law. Is it just the receiver group? Is it what do they have to sell in order to be a felon?
So, I mean, there's a a good point there about the, or good question there about the, what the definition means. So there is a distinction in the bill between the unfinished frame or receiver, but the 5101 definitions of what a firearm means are changed to include an unfinished frame or receiver as defined in 5701. So for the purpose of Title V, Subtitle 1 of the Public Safety article, which governs regulated firearms, the term firearm would include an unfinished frame or receiver. So somebody would be subject to those penalties for selling an illegal firearm if they sold an unfinished frame or receiver. But there is a distinction made in the new subtitle that's being made between, you know, a firearm that doesn't have a serial number versus an unfinished frame or receiver. So the prohibitions on selling, buying, offering to sell, or receiving an unfinished frame or receiver, those are restricted to the bill as drafted about the unfinished frame or receiver, not necessarily the completed firearm. The possessory offense is for a firearm. Now, the firearm can be a receiver, but if it has reached a sufficient stage of completion to be readily converted into a firearm.
It is a firearm.
Right, then it is a firearm. There's a couple of logical hoops there.
That's on possession, but what about the sale? You lost me on the seller. So if the person sells the receiver without a serial number, is that going to be a 5-year under this?
So the bill is drafted, and I kind of want to make sure.
How about
I
not as
understand.
drafted, but as we amend it, what we got in front of us now?
Okay,
What
so,
we have, what we're about to pass.
right.
Because
as-
I don't want to do a 5-year felony on just selling the receiver. I think that's,
Well, I guess and that's consistent with how completed receivers are treated under current law. Current law, the definition of firearm includes a completed receiver in most cases. So if you do have let's say a polymer 80 or an actual lower receiver from Glock, for most purposes, that completed receiver is going to be treated just like a completed firearm is.
so what is the current, I think you were looking up, what is the current penalty then?
So, depending on the prohibition, but I'll just read the section we're, kind of familiar with recently. This passed a couple of years ago. Like if a dealer or other person sells, rents, loans, or transfers a regulated firearm to a person that person knows or has reasonable cause to believe is prohibited, that is a 5-year misdemeanor.
So actually, that's, with all due respect to the vice chair, I think this should be a misdemeanor, because that section, actually, I put that together with the Senate president before he's Senate president. That's actually hitting out illegal guns when they're like selling them and trading them off in street gangs. So I think you want to match this up with that. So I would think a 5-year misdemeanor, especially given where we are on the other part of the law, would make sense, because it would match up. Versus going to, I think a 5-year misdemeanor for that, the selling, and then a 2-year on the possession misdemeanor. That's what I think sounds reasonable.
I agree with that
So
completely.
can you go to Senator Carter? I'll come to you, Bailey.
Sorry.
Since she's on this. Good. Good. Yeah, sorry.
I was saying, I agree with that completely. I think the 5-year misdemeanor is appropriate, especially since it's in line with the other section that we passed a couple of years ago. But I also think we can up the fine, because again, when you have this profiteer, this dealer hitting them in the pocket as well is important. I don't see the need to have a first time be a felony either. I think that the fact they're now prohibited and they got that stiffer penalty and it's in line with the other thing makes more sense than making it a felony for the first time.
For possession. Okay, so Jill, and Mike, you're saying 2-year for just a possession misdemeanor, and then 5 years. Philip?
Or,
For the seller.
sale, yeah.
And it can be a heavier
I
fine,
don't know,
too.
what do you think, Jeffrey, for this?
So,
I think you should.
so that's, let's finish up here. Do you want to? Senator West and Senator Bailey, is it relevant to just the discussion before us right now, or is it on a different topic? About the penalty? Okay, Senator Bailey.
Trying to figure out here why you just don't holler out, and why you sit here for 15 minutes with your light on. But the issue is, when we're talking about this 2-year penalty for somebody with possession, right? I think that's extremely harsh for somebody that is, potentially, right? Somebody that's got a firearm to protect themselves or their family in their house, right? And for some unknown reason, right, government shows up, right? They haven't committed any other crime, right? And all of a sudden, we're saying 2 years?
That's kind of the law already for illegal possession of a gun.
What's your question, Greg? Is it serialized or unserialized after this?
So if and I guess that's where I'm going with this, is the point is, when we had the hearing, we talked a lot about the fact that a block of anodized aluminum could be a frame, can come out of that block, right? There is no doubt about it. And I know that if, by the way, I read the law that says that if it is listed as a block that for a receiver, no, whether it's 0% or a 90%, right, that could be covered, right? That person that buys that, right, or has one right now, because a lot have been sold, and they've got blocks. Where I come from, we have Beretta, right? 1 million people have blocks of aluminum. They're square blocks of aluminum, anodized aluminum. Is that possession at all? Because some of the people that work there, they have really nice machine shops. They're able to make custom guns for themselves, right? They make that gun whether they have,
Depends on when you got it.
right?
So I just wanted to sort of read the definition of an unfinished frame or receiver, because I think, if I'm understanding your question, Senator Bailey, it's, is the person who is possessing an unserialized block of aluminum guilty of an offense under the possessory offense? And I think the answer is no, because that block of aluminum hasn't been turned into what would be termed a firearm at that point. However, if the person were to receive or sell or offer to sell that block of aluminum, I think the provisions of subsection A.
I'd rather not get into the sale of it.
Okay,
I want to talk about the people that are sitting at home right now.
with a block of
that
aluminum.
have a block of aluminum at their house, right? That all of a sudden we're saying, hey, you've got one of these, you need to go to jail for 2 years.
I don't think so, because there's a distinction in the subtitle between an unfinished frame or receiver, which it seems like the block of aluminum could be termed because it's been marketed. It's a billet essentially that's been marketed as being something that you would turn into a frame or receiver, which could bring it within, I guess, the definition of an unfinished frame or receiver. But sitting at home with that, because there's this distinction in the law between a firearm that's unserialized and an unfinished frame or receiver that's unserialized, I don't think that that's going to fall within subsection B, because it hasn't reached that state of completion to become a firearm.
So, no disrespect, but I don't think, right, and the way that it gets to interpreted, by people, right? It gives me a lot of concern, just me personally. Right? It either is or it isn't.
Well,
Right.
and my only cause for hesitation there is that earlier in the bill, in the public safety article, if you turn to page, let's see, page 2, if we're just going off of the bill or the reprints, in 5101, it is saying that in that particular subtitle, it is classifying a firearm as including an unfinished frame or receiver. If somebody were to sort of extend that to this new subtitle, then,
Right, my
right,
point
actually,
is-
and it would be. So,
so-
Senator, I want to
yeah,
backtrack.
Right, my point is right here. It says an unfinished frame or receiver as defined in 5701. That's right, and
No. And actually, I need to backtrack there because I just looked and on page 4 of 6, in line 8, firearm does have the meaning as stated in 5101, so you're actually correct. That billet would be a firearm as it's drafted, you're correct.
What bill, what
Right.
are you talking, like?
So,
He's talking.
so the idea is if you had a block of aluminum that was marketed as a, something that could be turned into the frame or receiver of a firearm, that based on the definition in 5701H2, that because it was marketed that way, it is classified as an unfinished frame or receiver. Now, 5101 of the public safety article says that a firearm, that definition does include an unfinished frame or receiver. So the applicability is anything that is an unfinished frame or receiver is now a firearm for the purposes of,
If market is such.
right.
Doesn't matter the timeline.
No, actually, I mean, pretty much as soon as the effective date of the bill
If you
happens.
acquired it before the effective date of the bill.
No, because it's gonna be a firearm now.
So it doesn't matter when you acquired it.
I mean,
Thank you. This one, I don't think this is that complicated. The definition of unfinished frame or receiver is an article that, quote, "has reached a stage in manufacture where it may readily be completed." So a block of metal.
Look at the or, Chris.
What?
It's the or after that, number 2.
Oh, it's,
Anything that's marketed or sold. To become used as a frame or receiver.
oh, I see, okay.
It's the or
Yeah,
that.
all right. So the second may be problematic.
Yeah.
I had a separate question. I'm not too worried about blocks of metal. But, so, my concern is Gramps. So Gramps, over the last 3 decades, has acquired a couple of guns from good friends, and these have been sold to him as really highly unique guns that have been manufactured, and they're lovely, and Gramps has these guns upstairs in a trunk. And the family knows that Gramps has his guns upstairs in a trunk. And after this bill passes, is Gramps going to be guilty of a misdemeanor subject to 2 years in jail? So this passes, and the stories in the newspapers and the family members say, "Oh, yeah, Gramps has got that. Gramps, you know, you got some illegal guns upstairs." And Gramps says, "Arr!" And he's not gonna go to find some dealer and get stuff and get serial numbers. So, yeah, he knows about them, but what are we gonna do about Gramps?
Send him to jail.
Oh, Gramps knows it's not
Yeah,
serialized?
his grandchildren said, Gramps, I saw an article in the newspaper, those gun slips there, they're illegal because they don't have serial numbers on them. And Gramps goes, "Arr." He's 82 years old and he's not about to go running around the state trying to get serial numbers added to his guns.
I mean, you're
And
not
all of a
compliant
sudden,
with
so is Gramps a miscreant? Can he be put in jail for 2 years?
Well, you know that what? Actively disobeying the law, so.
Mens rea, though, so, I mean, most stuff we pass here does not have that intent in there.
Let's fix this.
He'll have Chris Rest as lawyer. Did you?
All right, so what do you want to do with the Blanco? So, the matter is the penalty, so that's the amendment before us right now.
Do we have to leave 2 in here? Why don't we just keep 2?
Well, what is the current amendment? Can you reread the amendment? The proposed, whose amendment is it to propose that? Okay, got it. Senator Carter's amendment.
So, how it would read is, just if you're following along, a person may not sell, offer to sell, or transfer a firearm unless it is imprinted with the serial number described under subsection B of this section, so that it meets the serialization requirements. And, keep in mind that nothing in the act applies to something that was manufactured without a serial number before October 22nd, 1968. So those unserialized firearms we're not talking about those. So this is just adding like that new prohibitor because you're going to have a difference in penalties, and basically anything that can affect the penalty needs to be decided by the fact finder, so the judge or the jury. It can't just be something that you have a different penalty for. So a person who is involved in that violation of subsection A, which is the kits, or in sells the firearm that isn't imprinted with a serial number would be subject to a misdemeanor not exceeding, imprisonment not exceeding 5 years and a fine of, the current fine is $10,000. So do you just want to keep that?
You say $15,000.
Right, it's up to. It's a 5-year misdemeanor.
Misdemeanor now.
I think that's right in line.
Okay, so
Right, so it would be,
It's the same as the other one.
it would be new language on page 5, and we'd be putting it in below line 23 and basically creating a new subsection C and D. So subsection C would now have a prohibition on selling the unserialized firearms. And the new subsection D would just lay out all the different penalties. So subsection D would read, a person who violates subsection A, which is the kits, or subsection C, which is the new prohibition on selling the unserialized firearms, would be guilty of a misdemeanor and subject to either or imprisonment not exceeding 5 years, or a fine, going with the current fine, that would be $10,000. And then there'd be a new paragraph which would say that a person who violates subsection B, which is just the possession, would be guilty of misdemeanor, and you guys wanted to go with 2 years? Okay.
So hold on, we're talking over here.
2 years, that's the parallel.
Hold on, 2 years, but we were discussing, we don't really have 2 years in anything in here. What if we did a year? We don't really use,
Yeah. We got that.
I try.
Come on. He's not a prohibited person anymore.
Go ahead, Jack.
And we're talking about the possession?
Yeah.
Right, but okay, so let's talk about the 2 years for somebody that has just the block of anodized aluminum sitting in their garage. I don't know how we fix that, because that's possession. It doesn't say anything about marketing. So we're talking the penalty for well, I don't see the difference. Because if you got a penalty for possession, right, and we, so
We're about to address that.
well, however
In like
we
2
address
seconds.
that, for me, would determine how long I think the other penalty should be. I don't know if that's clear as mud.
Okay. Well, all right, I got you, I understand. I'd like to adopt the amendment, and we could do a roll call, or we could just say, Jack, we are going to address your issue, but I'd like to adopt. Go ahead,
This is the penalty amendment.
the penalty amendment.
Let's
adopt two, and then somebody can offer something else.
Got it. All right, is everyone okay with that?
And
I know-
then-
I know Jack's down on the penalty amendment.
So,
Yeah,
and just for clarity, we'd be striking on page 6,
All of 5704, which provides for the penalties currently for the whole subtitle.
okay, now let's go ahead to the market.
Selling, right.
And possessing
Possessing
is
is-
misdemeanor and up to 2 years.
Right.
So why on page 4 do we need H2? Is that necessary? Because that causes Jack's problem.
Well, that's what we're talking about now.
Right, why do we need H2?
We're talking about it.
Okay, let's talk.
Yep. How do you, I don't know how to fix this. Do you need that?
So we had the Second Amendment advocates say, well, I mill out all the metal pieces, so the high-end firearms, but I always buy the receiver group because it's plastic. How could they buy those at all anymore? Would we totally make that illegal and they have to carve them?
So you can go to a gun store and buy a completed receiver, so something that has reached the state of completion already where it would require a background check, it would require
Would that be
filling out that
serialized?
4473 or 77R. Right, and it would, as long as it had reached that state of completion. That isn't changed under this because
Is that how they're sold now? I never
those
bought a
are sold
receiver.
as firearms, so you'd need to go through the same background check
But
process.
but it comes with the serial number on it?
Right.
Okay. All right, so if I'm having my lathes and my metal lathes and I'm carving this out, but then I want to buy the receiver group.
Right.
I can go to a firearm store, I can buy the receiver group. It would require a background check because I'm buying a firearm, but it would have the serial number on it. So it's possible to do that.
Right, if it was at that state of completion where it required the serial number, you could buy it from the firearms dealer, yeah.
Serial number on it to be legal, right?
H2? Look on page 4, H2. All we have left would be H1. Aren't you comfortable with that?
I think that would be a good issue, and I don't see how that affects what we're doing here.
No, I don't either.
Right, negatively.
It solves your problem, and I
Yeah.
don't think it affects anything else.
And it doesn't make the people that are hobbyists at home right now,
Right.
it doesn't make all of them criminals.
Exactly.
It's just not the intent of what you're trying to get at.
No, I understand, but then what we're talking, and we talked about this earlier this week, we just talked about it now, but then you have these people that are gonna sell like a milling kit with with a block of metal and instructions, and then they'll be able to get around it.
You
They'll
don't
market
think-
it as, hey, I'll give you this kit and a block of metal.
I just don't believe that. And that is not practical.
No, I hear you.
There is no way that somebody's gonna go out and spend $20,000 to buy the lathes and the machines to be able to turn a block of metal into that. But there are definitely enthusiasts out there, right, especially in my area.
Yeah.
Where Beretta was, where they have bought that high-grade aluminum that is capable of doing that, right? All the people that work there, they have them. They weren't serialized. This was never a crime. They have them. There's nothing wrong with having that sitting in your garage. That's what a 92 FS came out of, right? That block of metal right there. That is what this is saying, that anybody that has one of those is now going to be a criminal. And that is wrong. That is not right. We should not be doing that. Right? Because it would take an incredible amount of work and time and machines that nobody has, right? Except a few of those hobbyists around here.
If you've got those kind of MacGyver skills, you could probably go to Home. If you're that MacGyver skills, you could probably go to Home Depot and fashion something.
In all seriousness, I'm just going to say that what we're talking about right now has nothing to do with what the police came in here and talked about ghost guns. This doesn't have anything to do with what we're trying to address.
Been seconded. Is everyone okay? Yeah.
H2. So 5701H2.
Okay. Yes. So now the bill is before you with the amendments. I'd like to roll it. So go ahead, Senator West, go ahead.
Could someone just,
Let me get Senator West real quick, and then I'll come right to Senator Lee.
what can council say which would deal with my hypothetical of Gramps with his guns, 80 years old, and his grandkid says, Gramps, you got some illegal guns up there, and Gramps doesn't go get them serialized? What happens?
He violated, if he knowingly did it, he's gonna be in violation.
I mean,
Mens
I've
rea
worked
is
in
a
this.
high standard.
I worked in this field for quite a while.
Yep.
And let me tell you, these 80% lowers are something that is relatively new, right? So Gramps is not going to have a gun. If it's unserialized, it's going to be prior to 1968, right? He's not going to have one from the 80s because there wasn't these 80% lowers that were running around at that point in time,
No, but
right?
there could have been guns made by a handyman in the basement. You know, a guy who loves to create guns in his basement. He creates 4 guns a year.
He can make his pitch to the judge.
All right, I hear you.
Before you, as amended,
Can I just raise this point? If you want, okay. On line 16, page 4, if you add the word readily to that, would that solve the issue about the aluminum block? Yeah, line 16 on page 4, add,
it's out. So we are rolling this bill with amendments. It's been seconded. Is everyone, we'll do a roll call?
okay, all right, so for the entire bill.
On the MSP.
Oh, sorry, excuse me. Sorry, hold on. All right,
Just
that's,
Fill in the language
that's, yeah, for that process, we voted on the concept for the registration process. Okay, so we're doing a roll call. On the bill,
Vice
this is
Chair
on the bill.
Waldstraker,
Yes.
Senator Lee,
Yes,
Senator Castley,
Pass.
Senator Heddleman,
Yes.
Senator West,
No. What? You need me? I'll pass for right now.
Senator Sidnor,
After all this, yes.
Senator Watson,
Yes.
Senator Bailey,
No, I'm gonna tell you, because I know these gun bills are bad, I know that the whole thing with ghost guns is really dangerous for all of us, and you guys worked with me on this, and are not gonna make these hobbyist criminals. Yes.
Senator Carter,
Yes.
Senator Huff,
Yes, and I'll just explain my vote. There's probably nobody who's more pro-Second Amendment than me, but our state's attorneys came in, the police came, actually, I talked to my Frederick County sheriffs. They're pulling these out of cars. This, in my opinion, when we did the long gun bill a couple years ago, I didn't think that matched up to long guns being used in epidemic of crime. These are. My locals are coming to me saying they're pulling these out of cars, they're pulling them out everywhere. Every concern that we had, that we brought up, the hobbyists wanted to be able to serialize them, do them themselves. That's in the bill. They want to be less than 2 years. They want to be 2 years, so they're not prohibited. That's in, and we dealt with the other parts. So we've dealt with all the concerns that were brought forward. So I'm voting yes.
Senator Castley,
No.
Senator West,
I listened carefully to what Senator Huff just had to say, and I'm going to vote yes.
Enthusiastic, yes, I mean, this is a big problem in my district.
right, Chairman Smith.
Yeah, that's, yes, it's been a big problem in my district as well and across the state. I want to commend Senator Lee for her tireless work and advocacy. You just changed the game. You prohibited ghost guns. You set up a regime in which it's going to be registered in the state police. There's going to be an automatic background check for people that have unserialized firearms in their possession right now. This is good work. This is really good stuff. So,
Too late.
congratulations. All right, good deal. With that, voting is over.